Welcome back to Stanford Legal, where we look at the cases, questions, conflicts, and legal stories that affect us all every day. I'm Pam Karlan, along with Joe Bankman, and today we're talking about labor law with our colleague Bill Gould. Joe.
Bill, what you've been describing is a situation where union membership becomes almost voluntary because you can get the benefits without paying for it, and that threatens unions' existence. So how are they going to respond to this?
Yeah, I mean, you're absolutely right. Why, if I can get the benefits, why pay anything? And so I think that there are about 5 avenues that have been suggested and discussed in terms of where unions go from here. One is that California and New Jersey have enacted statutes which give unions greater access to government property for the purpose of trying to recruit employees, particularly new employees, during the orientation periods.
So this is an opportunity for unions to try to persuade people that even though they don't have to pay, they ought to.
Yes, right. And a second is that it's been suggested by one of the fellows who was a co-author of our brief to the Supreme Court that we ought to have a statute, that the states ought to enact statutes which allow the non-union person who doesn't want to pay dues to the union to pay nonetheless to a charitable organization of their own choosing if they want to object. And that would have the purpose, and that's been adopted under the National Labor Relations Act for people who have religious objections to union membership. That would have the effect of eliminating the free rider problem, because you'd have to pay somewhere, not necessarily to the union. It may not help the union treasury, but it would address the free rider problem. I think that it's quite possible that this Supreme Court may look skeptically at this kind of legislation, seeing it as an obvious surrogate for what existed before. But it is different, and the worker is not being required to pay to the organization that he or she disagrees with, but rather to an organization that they agree with.
So you could pay to your church.
That's right.
Or Stanford Law School.
That's right. Anything that you agree with, like Stanford Law School. Yes.
And the idea there is just that if people are not getting to keep that $120 either way, they may say to themselves, I might as well give it to the union that's representing me. So is the idea that some of this will lead people not to give the money to charity, but will lead them actually to say, I might as well give it to the union?
I don't know that the discussion has been quite as refined as that, Pam, but I think the basic idea here is that it will deal with this free rider problem, whereby I can get something on the cheap for nothing, and therefore, everybody will desert the union, or virtually everybody except somebody who has some kind of ideological predisposition to be for unions. It may be that a consequence of this is along the lines that you described, but I'm not sure that the discussion has been quite as refined.
I would think that would be the union's hope, wouldn't it? Is that when they support this kind of legislation is, well, at least then people will say, as between giving the money to a particular charity and giving it to the union, I should think about which one's better for me. And actually, giving it to the union's better for me because that'll strengthen the union that will make my job better.
Well, it eliminates this basic incentive to be non-union. You don't get the benefit. You don't get unionism on the cheap.
Right.
This way is
right.
the way we can say it. A third.
Can I just say
yes.
one thing for our listeners, which is this is Stanford Legal, and today we're talking with our colleague Bill Gould about the Supreme Court's recent labor law decision in the Janus case. So you were saying, Bill, that there's a third alternative as well.
Well, there's a third alternative. The operating engineers in Illinois have filed a complaint saying that constitutionally, if people don't have the obligation to pay us dues on the grounds that it interferes with their right not to associate with us, we don't want to associate with them either. And we want to only represent our members. and in effect to eliminate the system of exclusive bargaining representation which exists now. It may be that some unions will see this to their advantage if they're in a key position, if they can threaten to shut operations down by walking out and disrupting an enterprise. They may be in a strategic situation to advocate this. But in fact, the other side, the right to work side, is very interested in this also because they see an attack upon the principle of exclusivity as another way to eliminate what they call compulsion and to weaken unions in the process.
So can I ask you, you talk about this in the context of the exclusivity, but it's also a little bit about the duty of fair representation there, right? Which is presumably the union would then say, well, we'll negotiate for higher pay for our members than for other workers.
Right. But yeah, our members and nobody else. Everybody else, you're on your own. And it's a so-called members-only arrangement, which is, by the way, lawful, but which cannot be compelled. And what you do, the union would say, is eliminate this concept of duty of fair representation, at least as it relates to non-union employees who might be affected by this. But as I say, this really cuts two ways. The enemies of collective bargaining, the National Right to Work Committee, almost advanced this in the Quinn against Harris case in 2014, one of these Supreme Court decisions.
Bill, you've used the phrase right to work, and we've talked about it a little bit, but it's a slogan or a phrase we hear. Am I right in thinking it's really a right not to pay union dues?
It's a right not to pay union dues. It's a right not to be affiliated with a union in any way, depending on the form that the statute takes. What the Taft-Hartley amendments did was to allow the states to enact so-called right-to-work laws, which, as I say, don't guarantee anybody a right to work, but rather a right to disaffiliate. And 28 of the 50 states now have enacted such right-to-work laws. I've said in the past that the Janus decision really is a decision which, again, interfering with the political process, establishes a national right-to-work law in the public sector.
Well, we've been talking with Bill Gould here, and what we've looked at is what happens when unions, in effect, can't charge for their services but still have to represent employees, and what the union's response will be to this latest Supreme Court opinion.
So thank you for joining us on Stanford Legal here on Sirius XM Insight 121.